the opening of the trial on July 11, 2011, the defense expressed its desire to submit preliminary objections with regards to Kwoyelo's indictment. In response, the judges indicated that they had not expected preliminary objections to be brought during the plea-taking phase of the trial. The court set 25th of July 2011 as the date on which the defense would be given the opportunity to submit its preliminary objections. On July 25th, John Francis Onyango, lead defense counsel, assisted by Nicholas Opio, indicated he had 2 issues to submit orally. In response, Justice Akiki Kiza expressed dismay, once again, that no formal written objections had been submitted to the court prior to the hearing, as earlier indicated.
We are under the impression that the formal bit of the application we talked about was only in regard to amnesty and confidential issues, but in regard to disclosure, we were under the impression that we still make
you even withdrew. No, that's not right. You even withdrew and we expunged what transpired. How would you come back today and say the same thing?
My Lord, I want to like that direction. We now make an application to our submission.
The prosecution also objected to the oral nature of the application, arguing that, according to Section 58 of the Trial on Indictments Act, motions made to quash the indictment should be made in written format.
The understanding under Section 58 is that after plea taking, no objections can be raised for quashment of the indictment.
Section 58, subsection 2 reads, "Every such motion shall be delivered to the Chief Registrar or other officer of the court by or on behalf of the accused and shall be entered upon the record." Section 58, subsection 1 reads, "If any indictment does not state and cannot by any alterations authorized by Section 50 be made to state any offense of which the accused has had notice, it shall be quashed either on a motion made before the accused pleads or on a motion made in arrest of judgment." In response to the prosecution, the defense team argued that a procedural issue should not override an issue of substantive justice and prayed that Section 58 of the Trial on Indictments Act should be interpreted in light of Article 126, Clause 2, Subclause E of the Constitution.
My Lord, the sum effect of the argument of prosecution would mean that after plea has been taken, the court should turn a blind eye to any illegality that has been discovered.
Court lock wine ponen balmoke la chain because walk.
We think that is an erroneous conclusion. That any illegality needs to be addressed with substantive justice.
One only kagin moro kagin mo mapopo nen karwe politika warani court bir ko lock wine te bir nyam tiere chiki nyam ye dan we ben monia.
My Lord, we invite the court to address its mind not only the provisions of Section 58 of the TIA, but the principle, the larger principle of legality.
Patika legal court, iponen again, china pirabit your board in Edmerongi, long mamaho, momapio pore.
And in the interest of a fair trial and substantive justice.
The defense team further added that during the plea taking on July 11, 2011, it had in fact asked the bench for guidance on this topic and that the judges themselves had instructed the defense to raise its preliminary objections at a later time.
Requested for guidance
on
whether we should allow the accused to continue taking plea when we have an objection.
Ni birugi mete ki miyo kama kote kome mete ki gama do nagi mori kome nyo wakel ko mama wo.
My Lord, the guidance was that we would raise preliminary objection at a later date.
Justice Akiki Kiza adjourned court until 11 a.m. for the deliberation whether to allow the defense to submit their preliminary objections orally. The hearing resumed at 15 minutes past 12 p.m. The bench overruled the prosecution's objection to the defense's failure to provide written statements and allowed the defense to raise its preliminary objections orally on the grounds that procedural issues should yield to substantive justice. Although Section 58 of the Trial on Indictments Act reads that a written statement shall be delivered, the court concluded that the meaning of the word shall in this context is directory rather than mandatory, and that the court's refusal to hear the defense's oral preliminary objection would be tantamount to denying the accused a fair hearing.
In the American case of Federal versus Learning Community of Hawaii County, 62 Hawaii, 666, 619 at page 2D, 95 of 1880, the court held entirely that the word shall not be read as mandatory when unjust consequences may result. In that American case, the court concluded that the word shall may be held to be merely directory when no advantage is lost, when no right is destroyed, when no benefit is sacrificed, either to the public or to the individual, by giving it that instruction. However, courts have tended to use a liberal approach in certain circumstances where the word shall has been used, as long as no miscarriage of justice is occasioned thereby.
Justice Akiki Kiza emphasized that the right to a speedy trial, according to Article 28, Clause 1 of the Constitution, should be honored by all parties.
The right to a speedy trial has to be adhered to by all parties pursuant to Article 28 of the Constitution and in accordance with Article 14.1 these nations covenant in civil and political rights to which Uganda is a signatory.
The defense raised preliminary objections relating to the prosecution's failure to fulfill its obligation to disclose mitigating and exculpatory evidence, the nature of the indictment.
Our first preliminary objection is on the issue of disclosure.
Nilo machel mafarochef mayam katkere yana lupeke kaden ma achombagamende dikatikere birubene.
Yes, we were served as agreed last time with witness statements.
Nekemege log chaden ketano gendele okere nyimkon meocha.
Our first contention is that the statements are highly redacted. My lords, out of about 77 statements given to us, 26 are redacted.
The indictment merely alleged without any particulars on how the conflict between the Lord's Resistance Army and the government of Uganda qualifies as an international armed conflict. In addition, the defense declared that it wanted to apply for a reference to the Constitutional Court to determine that the failure by the Director of Public Prosecutions and the Amnesty Commission to certify Kwoyelo's application amounted to discrimination.
The issue of amnesty. I mean, the issue of amnesty is like one of the biggest things we're now looking at. The ICD is all about prosecution of war crimes, whereas at the same time we have in place an Amnesty Act, which is exactly the opposite. It exempts people from criminal prosecution. So these things run counter to each other. So the defense team asked a referral to the Constitutional Court to challenge the constitutionality of the fact that the DPP did not certify the fact that Kwoyelo could receive amnesty, and that hence he has not received amnesty.
The judges, surprised by the defense's line of argument, asked why the defense brought forward its preliminary objections if the defense intended to seek a constitutional reference. The judges advised the defense attorneys to consult with their client and reach an unequivocal decision on whether or not to make a constitutional reference afterwards.
As a defense lawyer, you should be focused, purposeful, and know where you are going. Because the first time you came before this court, you had to make an application. Okay, Mr. Caleb Alaka had to make an application to expunge something from the record. Now you come, you're not so sure whether you want a constitutional reference or you want to make a preliminary objection, in which case we will still be seized of the matter. But if you go to the Constitutional Court, as my learned friends have said, colleagues, we will not have any say in it. It will have to be the Constitutional Court to decide. So you either decide we don't want anything to do, this case should just be stayed, let the Constitutional Court decide, or let us have a go before this court and they decide whether there was an international armed conflict or whatever else you've been submitting on.
Court adjourned from 2:30 p.m. to 3:15 p.m. The session resumed at 4 p.m. and the defense stated that after addressing the issue with the prosecution, they were requesting for a constitutional reference on the basis of Article 137, Clause 5, Subclause B of the Constitution that states, where any question as to the interpretation of this Constitution arises in any proceedings in a court of law other than a field court-martial, the court shall, if any party to the proceeding requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this article.
My lords, we have discussed with the prosecution. And we now agree that we should request for a constitutional reference from the bench.
The defense requested the International Crimes Division to stay the decision on the preliminary objections until clarification on the issue of discrimination has been obtained from the Constitutional Court. The bench concluded the session by staying the International Crimes Division proceedings pending the determination of the constitutional reference by the Constitutional Court. Court was adjourned at 4:23 p.m. The Constitutional Court had the reference on August 16, 2011, and details of the proceedings will be in the next episode.